As the Supreme Court gears up for its next term, all eyes are on one case, Duncan v. Bont. This case isn't just another legal battle. It's potentially the most significant challenge to a magazine ban we've seen in decades. And it could set a precedent that resonates far beyond California's borders. But before we dive into the implications of this case, let's take a quick step back. How did we get here? What's at stake? And why is everyone talking about it? Buckle up, because this is more than just legal jargon. It's about your rights, your freedom, and whether the government can control the tools you use to protect yourself. If you haven't already, make sure you subscribe to this channel. It's free, and it takes just a second. Plus, it helps keep this conversation alive. By subscribing, you let the powers that be know that this content matters, and it ensures you won't miss out on these important updates when they matter the most. Now, let's break down the case and the history behind it, because understanding the context is crucial to grasping what this all means. Duncan versus been around for years, almost a decade, in fact. It all started in 2017 when the case was originally filed under the name Duncan versus Becerra, named after California's then Attorney General. This case stems from California's Proposition 63, a ballot measure that voters passed, often dubbed Gunmageddon, for the strict new gun laws it introduced. Among the most contentious provisions was the hard cap on so-called large-capacity magazines, defining anything over 10 rounds as illegal. This sparked immediate backlash, and lawsuits were swift to follow. Duncan quickly became the tip of the spear in the fight against this overreaching law. It all started in federal district court with Judge Roger T. Benitez, a figure who's become something of a legend in California gun rights circles. Benitez, affectionately called Street Benitez by many, ruled in favor of the plaintiffs, effectively giving Californians a brief window of freedom, what came to be known as Freedom Week. For just 1 week, Californians could legally purchase magazines of any capacity. And to this day, those magazines are still legal to own and possess. But that week wasn't just a blip on the radar. It was a stark reminder of how court rulings can affect real lives. This wasn't about legal theory. This was about your range bag, your equipment, and the tools you use for self-defense. It was a brief but powerful glimpse into what real freedom looks like when the courts get it right. From there, the case began its inevitable march up the judicial ladder, moving through the Ninth Circuit and eventually reaching the Supreme Court. But then, everything shifted. The Bruen decision dropped like a bombshell in 2022, altering how courts should evaluate gun laws. Gone were the days of interest balancing tests. Now, courts were told to judge laws based on the text, history, and tradition of the Second Amendment. That's where Duncan's legal battle really heated up. Judge Benitez revisited the case, applying the new Bruen standard, and once again found that California's magazine ban violated the Constitution. But the Ninth Circuit, after some legal gymnastics, insisted that the ban could still stand. This direct clash between the Supreme Court standard and the Ninth Circuit's defiance is what makes Duncan such a pivotal case. So, here's the million-dollar question. What happens if the Supreme Court refuses to hear the Duncan case? If the justices deny it, California's magazine ban would stand, and the Ninth Circuit's ruling would be solidified. Once that happens, the procedural gears start turning. The case would be sent back down to the Ninth Circuit, which would issue a mandate to enforce the decision. That mandate would officially enforce California's ban. And once that happens, magazines over 10 rounds would become illegal to possess under state law. And we're not just talking about new purchases here. Any magazine, whether it was bought decades ago or during the brief window of Freedom Week in 2019, would fall under this ban. The consequences would be staggering. People who legally purchased magazines would suddenly find themselves criminals, and the law would offer no compensation for the property taken. The state could demand magazines be removed, destroyed, or turned over to an FFL with no reimbursement in sight. This right here is where the Second and Fifth Amendments collide. The government is stripping away property without just compensation. That's a violation of fundamental rights. This isn't just a legal issue, it's a practical one. Tens of thousands, possibly hundreds of thousands, of law-abiding citizens would suddenly find themselves at odds with the law. Some might try to comply, hauling their magazines to police stations or gun shops. Others would hide them away, hoping to avoid detection. And still, others would outright refuse. That's where the boating accidents joke comes from, the idea that people might lose their magazines rather than hand them over to the state. But beneath that dark humor is a very real possibility: mass civil disobedience. When the government criminalizes common tools of self-defense, resistance is almost inevitable. Enforcement would be a nightmare. California could try to round up these magazines, but the sheer scale of it makes enforcement nearly impossible. Without pitting neighbor against neighbor, people would be forced to choose, comply, hide, or fight. And that's a weighty question for any citizen to bear. If the Supreme Court denies Duncan, the immediate consequences in California are just the beginning. This decision would send shockwaves across the entire nation. Other states with similar laws, New York, New Jersey, Hawaii, and Oregon, are watching closely. Some states have their own versions of magazine bans, while others, like Colorado, have restrictions that are just as damaging, if not more. If the court lets California's ban stand, it's not just about one state. It's about giving other states the green light to impose their own magazine limits with little fear of legal repercussions. It's not hard to imagine a future where states start pushing for even stricter limits. California's 10-round threshold might soon become the floor, not the ceiling. And if the Ninth Circuit's ruling holds up, other circuits might follow suit, creating a patchwork of restrictions that vary from state to state. This fragmented legal landscape is exactly what the Second Amendment was never meant to be. Rights should be uniform, not determined by geography. You shouldn't lose your rights when you cross a state line, and your right to keep and bear arms shouldn't vanish as soon as you enter California or New York. And let's not forget, this case is about much more than magazines. It's about the erosion of your rights under the Second Amendment. If the court allows this ban to stand, it will set a precedent that could lead to more restrictions, more limits, and more barriers between you and the tools you rely on for self-defense. But here's the key point. The justices have a chance to stop this madness. They have the chance to make it clear that your rights don't depend on where you live. If they deny Duncan, it sends a chilling message that the Second Amendment can be chipped away state by state, leaving millions of Americans stuck in a maze of conflicting rules. No one should have to wonder if they're breaking the law just because they crossed into a new state. This is about ensuring that the Second Amendment applies equally to all Americans, no matter where they call home. Now, let's shift gears for a moment. What if the Supreme Court takes up Duncan? After nearly a decade of litigation, the showdown would finally arrive. The court would have to decide whether so-called large-capacity magazines are protected arms under the Second Amendment, or if they're simply accessories the government can regulate at will. This isn't just a matter of legal technicalities, it's a question that will shape the future of gun rights in America. A ruling in favor of Duncan would be monumental. It would affirm that magazines over 10 rounds are in fact arms protected by the Constitution. That's a victory not just for Californians, but for gun owners across the country. It would send a clear message to lawmakers and courts alike. The Second Amendment means what it says, and attempts to undermine it will not stand. But the stakes go far beyond Duncan itself. A win here could spark a wave of challenges to similar laws across the country. It could open the door for challenges to bans on assault weapons, restrictions on concealed carry, and other limitations that infringe on your right to keep and bear arms. This case could be the turning point we've all been waiting for. If the Supreme Court takes on Duncan and rules in favor of the plaintiffs, it won't just be a victory for magazine owners in California. It could have a lasting nationwide impact. A decision in favor of the Second Amendment here would be a clear message to every state that wants to restrict gun rights. You cannot simply legislate away the core rights protected by the Constitution. The court would be putting a definitive stamp on what the Second Amendment really means, restoring its original intent in a way that no lower court can ignore. This case could finally settle the issue of what constitutes an arm in modern times. For years, anti-gun activists have tried to push the argument that anything that's not a firearm shouldn't be protected under the Second Amendment. But magazines, those seemingly simple everyday tools, are just as vital to the right to keep and bear arms as the guns themselves. A magazine is the vehicle that delivers your ammunition. It's as essential to the function of a firearm as the gun itself. And any attempt to ban them not only violates the text of the Second Amendment, but also undermines the very idea that citizens can arm themselves effectively. This decision could spark a legal domino effect. Imagine the floodgates opening. Other states with similar laws might see their bans struck down, and citizens in those states might finally get the chance to legally own magazines that hold more than 10 rounds. This would also challenge the constitutionality of other arbitrary limits placed on firearms and firearm accessories, forcing courts to reevaluate the government's authority to regulate arms outside of the Constitution's clear protections. However, if the Supreme Court rules against Duncan, it could solidify California's magazine ban and encourage other states to double down on similar restrictions. States that have yet to impose such bans could feel emboldened to do so, knowing that the courts have given them a green light. In that case, we could see a future where citizens' access to the most basic and effective means of self-defense is slowly but surely whittled away. That's why Duncan is so crucial, not just for gun owners, but for the future of the Second Amendment across the nation. When we talk about the stakes in this case, we're not just talking about legal theory, we're talking about the very real, very personal consequences for gun owners. If the court denies Duncan, the reality is stark. The decision would validate the idea that states can unilaterally strip away your rights at will depending on where you live. And with so many states already imposing their own versions of magazine bans, the floodgates would open for more states to adopt similar laws. For families in California, this decision would be especially devastating. Many law-abiding citizens who legally purchased their magazines during Freedom Week would suddenly face a choice: turn in their property, destroy it, or risk becoming criminals. For some, this is more than just a loss of property, it's an attack on their ability to defend themselves. These are the tools they rely on for personal safety, for home defense, and for protecting their loved ones. The reality is that for many people, owning a firearm with a high-capacity magazine isn't about having a weapon of mass destruction, it's about having the ability to defend themselves when seconds count. A law that takes away that ability isn't just unconstitutional, it's dangerous. And the worst part is, the law would force people to comply without any compensation for the property they've lost. If you think this isn't a big deal, consider what happens when the government starts taking property without compensation. This isn't just a violation of the Second Amendment, it's a direct assault on the Fifth Amendment as well. The government cannot simply seize private property without just compensation. Yet, that's exactly what California's law does. The law forces people to either surrender their magazines or face criminal charges, and yet it doesn't offer a single penny in reimbursement. This doesn't just threaten the rights of gun owners, it threatens the very fabric of our legal system. If the government can take property without compensation, where do we draw the line? What other rights could be stripped away next? This is why the stakes are so high. The outcome of Duncan versus Bont could set a precedent that impacts not just gun owners, but all Americans who value their constitutional rights.